The next few lectures in this series will put some meat on the arbitration process. This first one covers the time from when the case is filed until the arbitrator is confirmed. The beginning of a case, we always want to start with the authority for going forward with a dispute resolution procedure. The parties confer authority through their agreement, which could either be a pre-existing contractual requirement or an agreement that the parties draft after the dispute has arisen. In some cases, a court may also order an arbitration. There's also a statutory framework which supports the authority to have commercial arbitration. When there's interstate commerce, the Federal Act applies. It's called the Federal Arbitration Act, or you may hear it called the FAA. And if it is a state matter in Massachusetts, it's governed by the Mass Uniform Arbitration Act, which is Mass General Law, Chapter 251. There are links to these statutes at the end of this lecture, and you should take a look at them. These statutes provide authority that not only supports the rules of the providers and the ability of the arbitrators to agree to resolve disputes through arbitration instead of the court system, but they also provide some procedural direction for some aspects of the arbitration process which may be governed by the court system. Now, to get a case going, similar to mediation, there are filing forms. We talked about them in the previous lecture. They're usually pretty straightforward, and they're often available electronically. Note that for arbitration, if you are using an arbitration service provider such as the AAA or JAMS or CPR, there are filing fees which are usually due at the time of filing, and if a party submits a demand without a filing fee, that demand has not been properly filed and may be returned to the party. Once the filing documents are completed, all the fee requirements are satisfied, the first step that the AAA usually takes in a construction matter is to set up an administrative conference. And that is usually a telephone meeting. It could be by an electronic service, something like Skype, or occasionally it could be in person, but it is almost always some sort of phone call. It is usually conducted among the parties' counsel. Sometimes the parties are present, but usually just for practical reasons it's counsel, and an AAA staff member who is a trained dispute resolution professional. Generally, these meetings are sort of an intake process where the AAA staff gathers information that will help them be a liaison between the parties and the arbitrator once the arbitrator is appointed. At this time, the AAA may recommend other services which might be helpful. They may review whether or not the parties have mediated and generally go through all those early logistical issues. It's also a chance for the AAA to get some information about what sort of qualifications the parties may be looking for in an arbitrator, and also if that arbitration agreement included any special conditions or changes to rules. This is a chance to make sure everyone is aware of those special conditions and what they mean. There may be a few special issues that arise which are usually at least addressed in an administrative conference. One is a challenge to the authority to proceed, and the term for this, and this is a term of art which is very specific and does need to be used properly, is called arbitrability. There are two types of arbitrability. The first is procedural, which is who decides whether the dispute is arbitrable. The real question here is this arbitration itself valid? You may have a valid contract, but for some reason the arbitration clause itself may not be valid. A procedural arbitrability question is usually handled by the courts. The other type of arbitrability is substantive arbitrability. Does the arbitrator have the authority to decide this particular dispute? And this question is often put to the arbitrator once he or she is appointed. A classic example of this may be if an arbitration clause is contained in a private employment contract and it specifically carves out discrimination claims, but the demand comes in and in addition to other damages, there is a claim for damages resulting from discrimination. This could be the subject of a challenge to the authority of the arbitrator to proceed on that claim. Now, here, I said the arbitrator decides these issues. A party who's contesting the arbitration may not want an arbitrator to hear the arbitrability issue. in which case he or she can go to court. However, the arbitration process will probably proceed unless and until a court orders that it's stopped. Another preliminary issue that comes up, and we touched on it briefly earlier, are the issues of consolidation and joinder. Parties can certainly agree to consolidate cases or join new parties, but if they disagree, the American Arbitration Association rules set forth a very specific process. It's called the R7 process, and a special arbitrator with expertise in these areas is appointed. This person may or may not go on to serve as the arbitrator who decides the merits of the case, but this arbitrator is appointed to hear and decide the consolidation and joinder issues, and his decision is final and binding and cannot be reviewed by a later arbitration panel. Which brings us to the arbitrator selection process. If there are no other early issues, the next step in the case, and it should be taken fairly quickly, and most rules will set out time standards for this, but the next step is to get the arbitrators on the case. Arbitrators decide almost all of the rest of the procedural issues and certainly deal with the merits of the case, so it's important that they get appointed quickly. Now, if not modified by the process set forth in the parties' agreement, there's a default provision in the rules, and after that administrative conference, the AAA staff member will seek input from the parties about the types of arbitrators they're seeking. Are they looking for industry professionals? Are they looking for lawyers? Is it a one-arbitrator case, a three-arbitrator case? Should note that in the AAA's construction rules, there's a reference to a balanced panel. And this came from feedback from the actual users of the case, where some cases are so complex that they want a three-member panel, but it didn't make sense to have all the members of that panel be of the same profession, 3 lawyers or 3 architects. So that's one thing that will happen at the administrative conference. If the parties are going forward with a 3-member panel, the case manager will work with the parties to find out what type of case it is. So if it's more of a design issue, maybe you have an architect, an engineer, and a lawyer. And what will happen is the parties will get 3 separate lists, and they will choose one arbitrator from each list. There are different ways the parties can use the lists. There's often a striking and ranking process, but there may be other ways, and you can consult the rules for more details on that. Once initially appointed, the arbitrators must go through that disclosure process. Once the disclosures are received and issued to the parties can challenge the continued service of an arbitrator. AAA have trained staff who decide these matters, and they are usually final and binding. And the parties can't then challenge the service of the arbitrator back to the arbitrator once he or she starts hearing the case. The rules set forth time standards, and if the parties can't comply with those time standards and no extensions are obtained, then the default process is that the AAA will appoint the arbitrator. And again, different providers have slightly different procedures, but it's usually a pretty straightforward process, and absent party delay, it can be managed pretty quickly. And one of the benefits of arbitration is exemplified here in that the parties do have some control over who is going to decide their case. Before we move on to what the arbitrator does, we'll take a quick stop and look at the arbitrator's authority. Unless the parties limit it through their agreement, or if there are some specific limitations in the rules, the arbitrator's authority with respect to the procedural aspects of the case is very broad. This extends to things like scheduling, evidence, and the hearing process. One of the limitations on the arbitrator's authority is that the arbitrator can only issue orders with respect to those actual parties in the case. They cannot reach outside the case and issue orders to non-parties. And when we get to the award, we'll also review that the arbitrator cannot award anything that is not directly sought by the parties. Another important concept you should know about is arbitral immunity. Much like a judge, arbitrators are immune from a suit filed against them as a result of their actions as an arbitrator. This arbitral immunity also extends to administrative organizations like AAA and JAMS. There are exceptions for misconduct, but it must be extreme misconduct. If as a result of an arbitrator's award, a business has to close. That is not the type of misconduct that it wouldn't even be considered misconduct. Or if a party feels that an arbitration award against him or her is a negative statement about the party, again, there's no action that can be brought. The type of conduct that might lead to an exemption from arbitrable immunity would be if an arbitrator had a stake in the outcome of the case and did not make the appropriate disclosures about his or her relationship with a party or the underlying subject matter, and proceeded to hear the case and decided the case and had some sort of personal gain as a result. That would be the exception to arbitral immunity. It's an important concept to consider, and it is necessary for the integrity of the process. Nobody would serve as an arbitrator if they knew they could be sued as a result of a party being disappointed with an award. And that concludes the first part of this lecture series.